Good evening. I look out at this crowd and I think perhaps you were mistaken. You thought Michael Jordan was coming, didn't you? That's why you're here. But I'm very happy to be here, and I will be talking about affirmative action. Why is it that positive discrimination does not describe accurately affirmative action? It's because, at least in English, discrimination has a very negative sense. Even with the word positive, then it appears to be almost a contradiction in itself. Affirmative action, and I will put this on the board, is a conscious allocation of resources to members of a previously disfavored group. That's what affirmative action is, and it takes many forms. But I'll leave that definition up there for the moment. I'm going to talk to you about four different things this evening. The first is the emergence of affirmative action, not affirmative action, but equal protection. The second is the civil rights era, if I remembered correctly. Yes. The third is federal affirmative action efforts. And then the last will be the U.S. Supreme Court and affirmative action. This is how I will organize my thoughts this evening. One cannot talk about affirmative action in the United States without giving some history of the United States. So forgive me if some of what I say you've heard before, but it's important to have that in mind when we talk about affirmative action. First, the emergence of equal protection. You know that our Declaration of Independence from Great Britain occurred in 1776. The Declaration was written in large part by Thomas Jefferson, who was greatly influenced, I might say, by Jean-Jacques Rousseau and by John Locke, philosophers. In the Declaration of Independence, it states quite boldly, "We hold these truths to be self-evident, that all men are created equal." In 1776, in the former colonies of Great Britain, for over 100 years, there existed the institution of slavery. All men were not, in fact, equal. But that's what the Declaration said. 13 years later, when we drafted the U.S. Constitution, that is the Constitution that is still in effect and dates from 1789, the Constitution contained provisions that protected slavery, while at the same time it professed to be a document that expressed equality for all. Protected slavery to the point that if a slave from the South, from a state where slavery was the law, if that person were fortunate enough to escape to the North, to a free state, the Constitution required that the authorities in the free state had to turn that person over to that person's owners, so that you couldn't even legally, by the Constitution, escape as it existed at the time. And then you had the Civil War in the United States. This dichotomy, a document that on the one hand speaks of freedom and in reality sanctioned slavery, that could not exist. The nation was itself divided. And so in 1861, we had the Civil War that lasted for 4 years, the War of Secession. At the end of that time, there were 3 very important amendments to the Constitution. The first, let me see. The First Amendment from 1865, which was the 13th Amendment of the Constitution, outlawed slavery. So even though President Lincoln wrote the Emancipation Proclamation in 1863, that did not outlaw slavery in the United States of America. It only attempted to free slaves who were in slaveholding states, in the South, actually. So in 1865, finally, over 200 years after the first slaves were brought to the United States of America, the Constitution declares slavery is unconstitutional, it is illegal. The Second Amendment, very important, the 14th Amendment, which dates from 1865. This is the amendment that guarantees to everyone in every state, citizen and non-citizen alike, the right to equal protection. Okay? Certain rights, the state cannot discriminate. And then the Third Amendment, the 15th Amendment, guaranteed the right to vote. Before 1870, if you were black, you could not vote. So in 1870, 5 years, if you will, after the Civil War, but it's black men who have the right to vote. Women did not have the right to vote in the United States until the 1920s. Okay? So this is just black men. These are called the Civil War Amendments. And they, in their totality, and the 14th in particular, are extremely important when it comes to the protection of rights, particularly when it comes to racial discrimination, or any discrimination, actually. Well, you had those 3 Civil War amendments, and then you had, in 1866, in between these 2 amendments, a Civil Rights Act that attempted, among other things, to guarantee to the former slaves the same rights that whites enjoyed, particularly when it came to contracts, or to own property, or to go to court. So you had all these protections, and yet, despite the fact that you had these protections, there existed in most of the Southern states what we refer to as Jim Crow laws. These were laws that provided that the races had to be separated. These are laws that provided that black children and white children could not go to school together, that black people and white people could not sit together on trains or on buses, that black people and white people could not be together, certainly could not marry. And I will point out that that did not change until 1967 in the United States. But I digress. Jim Crow laws. The Jim Crow laws were finally reviewed by the Supreme Court in a very important, horrible decision. The decision, Plessy versus Ferguson, decided in 1896. Mr. Plessy was a man in Louisiana who was 4/5 white, 1/5 black. He was traveling on a train, and he sat in the white section of the train. The conductor came and told him he had to move. He refused to move. He was arrested. He challenged the Jim Crow law of the state of Louisiana that said he had to sit in a car with blacks. The United States Supreme Court, the highest court in the land, the court that is the last word when it comes to the meaning and the operation of the U.S. Constitution, this court held that Mr. Plessy had no right to sit in cars with white people. This decision, Plessy versus Ferguson, actually caused more Jim Crow laws to be drafted in the states. There were some obviously in existence already. But after the Supreme Court decided this case, it got even worse. And it kept getting worse until finally, we come to 1954. But before that, I have to talk about what happened before that. I'm moving now from the emergence of equal protection now to the civil rights era.